I think if you have a case where both parties are familiar enough, like with the financials, so that you don't have to do discovery, because you see a lot of cases where one spouse kind of primarily handles the finances and the other spouse really doesn't even know what they have or what they pay for until the discovery process is complete. But if you have situations where both spouses are intimately involved with the household finances, they may have enough information already that you don't have to do discovery.
Welcome to the Herlihy Family Law Podcast, your trusted source for expert insights on navigating family law matters with clarity and care. Whether you're tackling tough decisions or seeking guidance for your family's future, we're here to help. Let's get started.
Welcome back to Herlihy Family Law. I'm Allison Herlihy, and today we're talking about mediation in family law cases. Mediation is a major part of many divorce, custody, and support cases, but it can also be a process that clients feel nervous or uncertain about if they've never been through it before. I'm joined today by two of our associate attorneys, Anna Eden and Walter Guin. We're going to talk about what mediation is, how it works, how clients can prepare, and what to expect before, during, and after mediation. Thanks for being here, y'all, in our office. Anna, for listeners who may not know, how would you describe mediation in a family law case?
So mediation can be a really useful tool in family law cases because it allows individuals that are getting divorced or dealing with post-divorce issues to come to an agreement on the same day in the same place, and craft something that is beneficial and more tailored to their family than just putting their case before a judge and letting a judge decide based on the facts that they hear in court. It can be a really, really useful tool for people to make sure that, what they are agreeing to going forward is going to work best for everybody.
Walter, why is mediation such a common part of divorce and custody cases?
Well, when you're getting divorced, it often takes a long time. From the date of filing to the date of trial, it's a long process. So mediation is often a good way to get it over sooner, or to see if there's common ground where you can settle everything way before the court date. And so it's both good for the court and for the clients.
Yeah. Allison, what do you think that clients most often misunderstand about mediation?
The main thing that comes to my mind is people that aren't familiar might confuse it with arbitration, which is another type of alternative dispute resolution. So in an arbitration, the arbitrator is sort of like a judge, like they're the decider of fact, and they get to make the ultimate decision about what happens, like kind of similarly to what would happen in a trial. But mediation, even if it's court order, is still a voluntary process. You can't be forced to do anything in mediation. The goal of mediation is to help facilitate an agreement that both sides feel like they can live with and, feel okay about putting pen to paper and moving on to the next chapter.
Anna, how do you explain the mediator's role to a client who has never been through the process before?
I think whenever I describe it to clients, I like to let them know that the mediator is almost all the time another lawyer. And it's another lawyer that has been practicing in this field specifically for many, many years. And it's someone who our judges trust to make decisions in cases, or, they have the insight from their years of practice to know what our judges might do in a certain situation. And so they can take that experience and that knowledge and help apply it to settlement negotiations without feeling like it's the other person's lawyer trying to get you to do something else. Like they act as a neutral party, but it's not just a random person, that we've chosen. It's someone who is very familiar with this field. We've all worked with many times. And even if it's someone that's appointed by a judge or it's somebody that we've agreed to, it's somebody that is familiar with this area of the law and they know what they're doing and they know what they're talking about.
Yeah. Walter, how's mediation different from a trial or a hearing in court?
I would say mediation is a lot more relaxed. It's just an opportunity for everybody to come to the same place and be, like each party will be in a room with their own attorney, and then the mediator will go back and forth. And if you're able to come up with an agreement, um, then you sign everything there that day and it's over. So I mean, it's a tremendous opportunity. It's not as contentious as a trial. And if it's unsuccessful, you're in the same place that you already were. So and nobody can talk about it at trial. You can't say, oh, but at mediation, you made this offer. I mean, that's inadmissible. So there's no pressure if you can't settle it. But if you can, it's a great opportunity for the client to have a hand in the outcome of their divorce.
Yeah. Well, speaking of admissibility, I think one key difference is that when you're in trial, the only thing the judge can consider is things that are admissible in evidence. And you don't have really that limitation in a mediation. There might be other factors that are important to the parties, but might not necessarily be things that could be admissible in evidence under the rules.
True.
Walter, what point in a case do you usually see mediation taking place?
I would say that is going to depend on the parties in the case. I think for most people, after you have completed discovery, a case is probably more ripe for most people to do mediation. However, the second I want to say that there are definitely some cases where the parties are willing to go to mediation before doing discovery. So I would say it primarily depends on what the key issues are in the divorce. But for most people, it would be after doing discovery, knowing what assets and debts and personal properties to be divided, knowing what everyone is hoping for as to custody, if that's an issue, and just at a point where you're waiting for trial and everything's essentially ready is what most cases would, when they would be ready for mediation.
Yeah. Well, Allison, are there times when mediating earlier in the case really can be helpful?
I think if you have a case where both parties are familiar enough, like with the financials, so that you don't have to do discovery, because, you see a lot of cases where one spouse kind of primarily handles the finances and the other spouse really doesn't even know what they have or what they pay for until the discovery process is complete. But if you have situations where both spouses are intimately involved with the household finances, they may have enough information already that you don't have to do discovery, so for both sides to have enough knowledge to be able to enter a fair settlement.
Yeah.
Anna, are there situations where mediation might be less productive if the parties are not prepared?
I mean, I think generally mediation is not going to be successful if the parties aren't prepared to do it. Like Allison was just saying, when there's a dynamic between a couple where one partner was the breadwinner and controlled the finances and the other didn't really have a whole lot of input into it, it's not going to be a productive mediation session if you have not already done the discovery. If you're representing the spouse that doesn't know anything about the finances, to have all that information in hand before you go to that mediation, because otherwise you don't know what you're trying to get. You don't know what you have to negotiate with. And if you don't have all of the necessary information going into a mediation, you're not going to be able to have a productive session or conversation.
Anna, what types of family law issues can be addressed in a mediation?
Pretty much all of them in a divorce or a post-divorce or custody issue. Even if you're not married and you're arguing over custody of a child, our juvenile court judges have been sending some cases to mediation now, just to mediate custody. But the goal, when you go to mediation is to settle your entire case. So whether you're back in court trying to argue, if you should have your alimony reduced or terminated, you can certainly try to mediate that issue. When you're getting a divorce, all of the aspects of your divorce can be mediated, dealing with how you're going to sell or, who's going to keep your house, custody, what you're going to do with your financial accounts, your debts. All of these issues can be mediated. I'd probably say it's more difficult to mediate cases where custody is just the issue and you've got the rest figured out, because custody tends to be the sticking point for most people. And it can be hard to give, or when it comes to your child. But, you know, overall, though, most family law issues can be addressed in mediation.
Anna, what should clients do before mediation to make the day as productive as possible?
So they need to go into mediation with an open mind. They need to, you know, ideally beforehand, they've prepped with their attorney, right, to talk about what their deal breakers are, the things that they're willing to concede to. But to be the most productive in your mediation, you need to go into it with the mindset of, I'm here to settle. I am here to get this over with. And I would like to, obviously keeping in mind that you want it to be as fair as possible for yourself. But, you know, what you may think is fair and what your soon to be ex-partner thinks is fair aren't going to be the same thing. So going into it and being willing to negotiate and work and put in the work and negotiate in good faith, making sure you have that mindset on the front end is going to be really helpful for you when you go into mediation.
I would say too, just on a really basic level, making sure you have a solid understanding of what is out there that needs to be addressed. Yep. Because I mean, I can't say how many cases I've had like where I've been the mediator and the parties come in and they're not able to even like articulate to you what the financial accounts are, what the debts are, even something as basic as like what their income is for the purposes of calculating child support, like really basic information.
Yeah.
That may seem kind of obvious, but you know, it's obviously not that obvious to some people.
Yeah.
You know, so just having all that lined up, or like, you know, sometimes you'll have people where they own like 15 cars. Well, we need to know the year, make, and model of all the cars, how they're titled, if money's owed on them, you know, all that kind of thing.
Yeah. Walter, how do you help a client think through what they want versus what they may be willing to compromise on?
I think talking to them about what the disputed issues are and what their non-negotiables are, and then also advising them what is likely to happen based on the circumstances. I guess pulling from my experience and what I've seen their judge do can help advise them on things that they want versus the way that I see it's likely to happen. Because I mean, you know, I think every case they're going to have non-negotiables. Like, this is important. I have to end up with custody, or I have to end up with the house. And so picking what we can use to negotiate with, I think, is really important, and it changes in every case. Because I think being realistic with your client is helpful for mediation. Because I mean, if you go to mediation, you throw out some crazy offer that everyone knows is never going to happen, then I mean, that can sometimes end the mediation right there. So I think just being clear on what's on the table and what you're willing to negotiate, I mean, is really helpful in finding that common ground.
Yeah.
Allison, sorry. What are some mistakes that people make when they come into mediation unprepared?
I'd say along the lines of what I was mentioning earlier. I can think of one case in particular, like without getting into the specifics, obviously, because that's confidential. But like the main thing was the main asset was a business. And the people came and they, you know, the position was, well, we think that's the primary marital asset. One side wants it to be divided. The other side doesn't want it to be divided. And then, of course, my first question is, well, does anybody know how much the business is worth? And the answer was no. No one had, you know, done a business valuation. No one brought any information that the value could be extrapolated from. So we really had nothing to talk about, you know? So, I mean, you get in a situation where both the parties have like paid the mediator to be there that day, paid their lawyers, and you really couldn't do anything productive at all. That's an extreme example. But I mean, obviously you're going to get the best use of your time and money if you come prepared.
Yeah.
I agree.
Anna, what can a client expect when they walk into a mediation?
So clients usually always think it's going to be like what they see on TV. Everyone's going to be sitting in the same room as at a big table, and they're going to be looking across at their spouse or soon to be ex-spouse, and everyone's just going to be arguing in one room. But it's the polar opposite of that. You will be at mediation with your attorney in one room, and your spouse, soon to be former spouse, will be in a separate space with their attorney if they have one. And the mediator will go back and forth between the rooms and exchange offers. Most of our mediators in Mobile and in Baldwin County try to minimize the communication and the opportunities for the litigants to see one another, because that can create tension and further conflict. And, the goal of going into mediation is to get the case settled and to work together. So if you don't have to look at the person that you're arguing with, it kind of makes it easier. That's the biggest thing that I tell them to expect, is that, it's just going to be us and the mediator. We're not going to be seeing, we're not going to be seeing your husband. We're not going to be seeing your wife. We're not going to see their lawyer. It's just going to be us. And that usually gives them a sense of peace and kind of, eases their mind a little bit about the situation. Walter, well, I feel like I already just answered this question, but I mean, do you know some of the other reasons why parties are often kept in separate rooms at mediation?
I do. So it's for a lot of reasons. I mean, in other cities, I know that they will do a joint caucus where everybody's in the same room. I definitely think it's very rare in Mobile and Baldwin County. But I mean, people going through a divorce usually don't want to be with their spouse. They want to be with their lawyer and get advice. Also, often there are domestic violence issues involved. And so if that is true, that's yet another reason why they shouldn't be in the same room. You shouldn't be in the same room as your abuser or alleged abuser. So I think that I think it's also a lot more conducive to being creative with settling your case, is not worrying about talking. You're just talking with your lawyer and trying to find that common ground, push for the things that are deal breakers for you, and then let some things go that you aren't that worried about. So I think it helps, make it a more relaxed, productive process.
I think too, one of the benefits and reasons why people stay in separate rooms is because, the conversation that you have with your lawyer is still a confidential conversation. And, mediators, when they come into the room and they give you their spiel of who they are, what their role is, part of that is that anything that you say to them, unless you give them explicit permission to, they're not going to go say to the other side. So having litigants be in separate rooms keeps that confidentiality aspect intact as well.
Absolutely. Allison, how do you help clients manage the stress of a long mediation day?
Well, y'all know that I'm a yoga teacher, yoga therapist in training. It sounds kind of cheesy, but I'm a big believer in breath work, just taking a few deep breaths, like in the nose and out the mouth. Also, I'm a big believer in walking. I think it's a great way to process thoughts and emotions. So I think it's great to get up and take breaks and walk around. One thing I think that a lot of clients think is helpful, but I often think is not helpful, is calling your family and friends for advice, because your family and friends love you, but most of the time they're going to tell you what they want to hear. They're not lawyers. They don't know everything about your case. They don't know all the considerations, and they're not able to give you objective advice. So, that's your lawyer's job, And so I think family and friends are great for emotional support, but they're not great for legal advice. So I would recommend avoiding doing the phone a friend or a mediation, because it often increases the stress.
Definitely.
Anna, what should clients understand about the back and forth nature of negotiations?
one of the bigger things I try to let clients know on the front end about how it's going to go with negotiation and how really it is going to be back and forth is that it's going to take time unless, you're already exchanged offers ahead of time and you're picking up kind of in the middle of negotiations when you go to mediation. Sometimes that the waiting period between offers can feel like an eternity. And clients will sometimes look like, why haven't they come back yet with what they're going to say? Why haven't they, what's taking them so long? And it's like, well, they're trying to craft a response based on what we've said. And I mean, they're talking through all of the points and they're weighing the benefits and they're weighing, they're trying to figure out how they want to respond. And I mean, if someone, in my mind, if somebody is taking time to respond to a settlement agreement or a first offer or even a second offer, I think that that's a sign that we're headed in the right direction because the people are taking the time to look at, what is in front of them on the table and trying to figure out what they're going to say back. If it's the back and forth becomes really quick, unless it's about one small issue, to me, that kind of signals right on the front end that it may not be too productive of a mediation session. But if it's going to be productive, usually the longer it takes between the exchange of offers, the better, in my opinion.
That's interesting because I have like the opposite opinion. Like, I feel like most of the mediations I've done, if one side is taking like a really, really long time to formulate a response, to me, that's usually a red flag that their expectations are super unreasonable or unrealistic. And like their lawyer and the mediator are having to work really, really, really hard to get them somewhere near like planet Earth in terms of what they're willing to do. Okay. But, everybody has a different experience. So, you can ask like 100 lawyers the same question and probably get 100 different answers.
Yeah. And I haven't had the experience yet of doing it from the side of being a mediator. So I try to spin things in a positive light. If a client's asking me, why is this taking so long?
Right. Allison, kind of along those same lines, how involved would you say the attorney is during the mediation process?
So your attorney is going to be there with you every step of the way. You're never going to be left like to the wolves by yourself. But in terms of the roles of the client and the attorney, your attorney is there to give you advice based on the way your facts are applied to the applicable law. And your attorney is there to help you make strategic decisions like what information should we reveal versus what information should we hold back? What offer should we make first, second, third? But the ultimate decision always belongs to the client because, of course, it's your life. Mm-hmm. So whether to settle or not, whether to accept or reject an offer, that's the client's decision. Your attorney is going to give you their opinion, but ultimately it's the client's decision. Walter, what are some of the most common issues or problems that come up in divorce mediation?
I mean, I guess as far as the issues, typically in a divorce, it's going to be custody, division of assets, debts, visitation. But then as far as problems that I see, often there will be discrepancies on like child support calculations, especially if you're involving somebody that is self-employed or they have multiple income streams or own a business and have business expenses. Often both parties are not going to agree on what number to put them at. So, I've seen that. I've seen there's differences when it comes to opinions on value of assets that are up for division, or the percentage of equity that someone should be awarded based on the length of the marriage, who owns the home, the amount of money that was put into the asset, or division of accounts and where that money in the account came from, when it came from, retirement accounts, how long they were married versus what's in the account. And then obviously you can't split a baby. So, I mean, custody and visitation is often a hot issue in that if you have two people that want custody, I mean, it's going to be really hard to settle because that's not going to be able to happen unless they have joint custody. But if they both want custody, then if you can't find some kind of common ground, if somebody doesn't back off that position, then it's probably not going to settle. Anna, in custody cases, what details are important for parents to think through prior to mediation and while they're there?
So if custody is something that is still, if there hasn't been a temporary order or anything like that that's been entered, the parties have to consider what they've been doing while the case has been pending with as far as custody and visitation goes. Have they already been sharing time with their children? Has their child been with one parent primarily, and have they already been following what the court's parenting guidelines are? Because usually, if you have to try a case, you have to put on some pretty good evidence to make the court change their mind about why they should change what you've already been doing as far as custody and visitation goes with your children. So when parties are going into mediation and they're trying to negotiate custody, they really need to make sure that details to consider are who, like I've already said, who the child has been living with while the case has been pending, what kind of visitation schedule they've already been having with the other parent, if there any new issues that have come up, while the case is pending about the fitness of another parent. Those are all things that need to be, taken into consideration. And I've had a couple of cases where I've been the guardian and the party called me during mediation to get my take and what my position is. Sometimes that can be helpful for parties with what it would be. And I've also done the same thing. I've had clients who have been really adamant about what they want as far as custody and visitation goes, and the mediator has suggested calling the guardian to get their input. And I've done that for clients. It's just ultimately parents need to think and consider what is going to be in the best interest of their child, though, and what is not necessarily it may not be what they want. They've got to put their child first and think what is going to be best for them going forward.
Yeah, I mean, that's really what it's all about. Well, Anna, on the topic of settlement, partial settlement, or not reaching an agreement, what happens if the parties actually reach an agreement at mediation? What happens next?
So if an agreement is reached, typically the mediator or one of the attorneys will prepare the agreement there, and they will print it, and everyone will sign the necessary paperwork with the mediator. That way you're walking away from the mediator's office with a signed agreement in hand, and then whoever the plaintiff is, their attorney will be responsible for filing all of the necessary documents, and the mediator will then file a mediator's report letting the court know that they've reached an agreement as well and that mediation was successful. So that's typically what will happen if a settlement has been reached. Walter, but what if the parties agree on some issues but not on everything? What happens then when they're at mediation?
So, I mean, you can definitely do a partial agreement, and it would be done just like you said. It would be typed up, signed, and then filed with the court, and then the mediator would file their report, and then you would you could still go forward and have your trial on the remaining contested issues. So, I mean, I've definitely seen that. I think it's more rare, but it's definitely possible because, if they agree as to all the assets, debts, financial accounts, but they just can't decide on custody, then they can go ahead and decide on everything except for that, have the hearing on custody, which would be a more narrow issue and probably a shorter hearing, and maybe even be able to get them a quicker trial date to go ahead and dispose of that, depending on the judge. So, I mean, it would be the same. It would just be a partial agreement, though.
There are also some circumstances too where, you may get to the point where parties have agreed on some things, but maybe they need to do a little bit more discovery, or they need to not recess the mediation, so to speak, and they can reconvene. That's also an option. And so you can kind of pick up where you left off with what the terms you've already agreed to, and then negotiate the rest, a couple weeks later after you're able to find out more information.
Correct. Like if you discover that somebody has another account that they didn't disclose, or an additional retirement account or pension or something that might kind of throw off your ability to settle the whole case. But I mean, maybe you can go ahead and do a partial agreement as to custody, or reconvene and come back on the whole thing, like you said, after you get those documents.
Mm-hmm.
So I mean, it just depends, because you're always finding things out that might be an issue or might not, which is why it's important to have thorough, completed discovery before going, if you can.
I think it's important to note, though, that, a lot of lawyers will take the position that they're going to settle like an all or nothing in terms of settlement. Mm-hmm. And I think some people do that because they think, well, if we're not going to settle everything, I still want to be able to use these other issues as like leverage on this, other issue.
Right.
So, doing a partial agreement is great if you can, but a lot of people aren't going to be willing to do that.
Right. I definitely think it's rare. It doesn't happen often. Allison, is mediation still useful even when the case doesn't fully settle?
I would say it absolutely is, even if you don't settle anything at all, because you get really educated about what the person's real position is that day. And you almost always learn things that you didn't know walking in.
Right.
And that's valuable by itself.
Kind of know what the deal breakers are and what the case is really about.
Yeah.
What happens if you don't have an agreement at mediation, Allison?
So the mediator has to file a report with the court saying that we participated in mediation, but we're not able to reach an agreement. And then after that, your lawyers have to request a trial date be set with the court. And it's important to note there too, like Walter kind of mentioned earlier, settlement offers are confidential. So if you don't settle at mediation, you don't have to worry that anything that's said that day can be used against you in the trial somehow. Like, oh, she offered me $1 million at mediation, but now she only wants to offer me $500,000. Well, that's not going to come up. It's not admissible.
Right.
Walter, what's one practical tip you would give clients before mediation?
I think to come into mediation with an open mind, and to be aware that you're not going to win all the points. You're not going to get everything at trial. So I think you have to really consider what is most important to you, and because I think if you don't settle, you're giving your case and your divorce to a third party to decide. And so if you do that, that's absolutely fine. But at the same time, you can't have regrets and think, oh, I wish I hadn't have pushed so hard for this thing that wasn't really important to me. So I think you have to really be realistic with your situation and the facts of your case, and the outcome that is truly important to you. Because if you don't settle and you have a trial, sometimes the things that you think are so compelling or important, the judge may not feel the same. So, I mean, you have to prioritize the outcome of your divorce at mediation, and be willing to find that common ground and settle things that are not, give up things that are not as important to you. And I think a lot of people want everything, but that's just not going to happen.
Yeah. Allison, what should clients remember when mediation feels frustrating or slow?
Well, like I mentioned earlier, it's still a great opportunity to learn things about the case. But I think an experience that often happens with clients is usually you have to remember that the first offer is not the final offer necessarily. And I think a lot of people will make their first offer, on the very, very high end of what's reasonable, or even they'll make their first offer like outrageous just to basically like test and see what they can get away with. So it's important to remember that that's a tactic and a strategy. So if you hear an offer that you find like is offensive as the first offer, don't just give up and walk away. There's lots of room to move and negotiate and lots of work that can be done. So to both of y'all, what's one thing you wish every client understood before walking into mediation?
One thing that sticks out to me is that I wish, and I try to make clients understand that when you're going into mediation, you may not necessarily walk out of that room feeling happy, because this is not a happy time in your life. But as long as you walk out of that room and we've settled, and you feel like what you've agreed to and what we've settled on is something that is doable for you and something that you can see yourself, living with and working with and being able to handle in the future, then we have been successful. I'm never going to advocate for a client to agree to something that I think is not in their best interests or in their children's best interests. But, some people will still feel very sad or will still be very upset even when they're leaving mediation and they settled. And I try to get them to understand that it's totally fine to feel that way, and it's pretty normal to feel that way. But as long as you are not regretting anything and you are comfortable with the decision that's been made, then we have been successful.
I wish that more people at mediation would understand that when you're thinking about settling your case, there's a lot of factors present. So you have to, in addition to everything that's on the table, you have to think about, if we don't settle and our trial is in a year, then we're going to have to keep paying the bills status quo. We're going to have to keep doing visitation as we have been. I'm going to have to keep paying my lawyer. We're going to have to pay. We might have to get subpoena documents or do depositions. And so there are other costs and factors to consider when you're deciding if an agreement is acceptable to you. And it's not only the stuff that's on the table. It's maintaining the current case, paying everybody, and then having that added stress of not having a resolution in your divorce. So I mean. You have to think about all that when you're like, if it's close, but it's not quite there, maybe it really is there. Because if you're having trouble paying the bills as they are, or, it's too stressful on you, then maybe all of a sudden that agreement is looking a lot better than you thought.
Yeah.
So,
I've definitely had clients who have said, like, I don't care what it says. I just want this over with. I'll sign whatever. And if that's how they feel and they've decided that's what's best for their life, of course, I would advise them, if you hold out, you can probably get more money or whatever the issue is. But if their value, like for their peace, is to have their freedom immediately, then that, they have to do what's best for them.
Right.
Yeah.
Right.
Well, mediation can feel intimidating, but it's often one of the most important opportunities parties have to resolve their case without leaving every decision in the hands of the judge. The judges are, of course, very educated and experienced, and they do their best, but ultimately they just get to hear like a few hours of your life story. They don't really know you, and whatever you can craft for yourself is more often than not going to be better suited for you than what the judge is going to come up with, despite, their best intentions to be as fair as possible. So with good preparation, realistic expectations, and the right legal guidance, mediation can help people make thoughtful decisions about their family, their finances, and their future. Thank you to Anna Eden and Walter Guin for joining me today. And thank you to our listeners for tuning in to Hurley Family Law. If you found this episode helpful, be sure to follow the podcast and share it with someone who may be preparing for a family law case.
Thank you for tuning in to the Hurley Family Law Podcast. Remember, you don't have to face family law challenges alone. Visit HurleyFamilyLaw.com or call 251-432-7909 to learn more.